Hello, law students and legal practitioners. Today, we will analyze the case of Santos versus Commission on Elections, GR number 155618, decided by the Supreme Court on March 26, 2003. Let's begin. Here are the legal doctrines of the case. Execution pending appeal in election cases is within the sound discretion of the trial court, provided that it is based on good reasons explicitly stated in a special order. The rule allowing execution pending appeal is an exception to the general rule on finality of judgments but is justified in election cases to prevent the frustration of the people's will. A combination of factors may constitute good reasons to justify execution pending appeal, including 1. Public interest or the will of the electorate, 2. The shortness of the remaining portion of the term of office, and 3. The length of time the election contest has been pending. The presence of two or more of these factors is sufficient. Forum shopping is committed when a party, after receiving an adverse ruling, files multiple actions involving the same parties, causes of action, and reliefs, in the hope of securing a favorable judgment from another tribunal. Forum shopping is a ground for outright dismissal and may constitute direct contempt of court. The Commission on Elections commits grave abuse of discretion when it gives due course to a petition tainted with forum shopping and when it unjustifiably interferes with the discretionary authority of a trial court to grant execution pending appeal upon clearly established good reasons. Here are the relevant facts of the case. Edgar Y. Santos and Pedro Q. Panulaya were rival candidates for the mayoralty position of Balingon, Misamis Oriental during the May 14, 2001 elections. After canvassing, Panulaya was proclaimed winner by the Municipal Board of Canvassers on May 16, 2001. Santos filed an election protest before the Regional Trial Court, RTC, of Misamis Oriental, Branch 26. After trial and revision of ballots, the RTC found that Santos obtained 2,181 votes while Panulaya obtained only 2,105 votes. Consequently, on April 2, 2002, the RTC declared Santos as the duly elected mayor and nullified Panulaya's proclamation. Panulaya both appealed the RTC decision to the COMELEC and filed a petition for certiorari. Meanwhile, Santos filed a motion for execution pending appeal. The COMELEC initially restrained the RTC but later dismissed Panulaya's certiorari petition and directed the RTC to resolve pending incidents with dispatch. On August 20, 2002, the RTC granted Santos' motion for execution pending appeal, citing good reasons, including the short remaining term of office and the need to respect the will of the electorate. Santos posted the required bond and assumed the office of mayor. Panulaya then filed multiple pleadings before the COMELEC, including a motion for reconsideration, a supplemental petition, and later a separate and independent petition, SPR number 37/2002, all seeking to nullify the same RTC orders. The COMELEC issued a status quo ante order and later annulled the RTC's order for execution pending appeal. Santos elevated the matter to the Supreme Court via a petition for certiorari, alleging that the COMELEC committed grave abuse of discretion and that Panulaya was guilty of forum shopping. Issue 1. Whether Pedro Q. Panulaya committed forum shopping before the Commission on Elections. Yes, Panulaya committed forum shopping. Forum shopping exists when there is identity of parties, identity of rights asserted and reliefs prayed for, and when a judgment in one case would amount to res judicata in the other. It is a ground for outright dismissal and is considered a pernicious evil that clogs judicial dockets and degrades the administration of justice. After suffering an adverse ruling in SPR number 20/2002, Panulaya filed a motion for reconsideration and a supplemental petition, and while these were still pending, filed a new petition, SPR number 37/2002, seeking identical reliefs. This clearly demonstrated his intent to obtain a favorable ruling from another forum, constituting willful forum shopping. The COMELEC should have dismissed SPR number 37/2002 outright. Issue 2. Whether the RTC committed grave abuse of discretion in granting execution pending appeal. No, the RTC did not commit grave abuse of discretion. Under Rule 39, Section 2 of the Rules of Court, execution pending appeal is allowed upon good reasons stated in a special order. In election cases, jurisprudence recognizes that public interest, shortness of term, and prolonged litigation are valid considerations that justify immediate execution. The RTC properly exercised its discretion by citing the short remaining term of the mayoralty position, the length of time the election protest had been pending, and the judicial determination of Santos as the true choice of the electorate. These circumstances collectively constituted good reasons for execution pending appeal. Issue 3. Whether the COMELEC committed grave abuse of discretion in nullifying the RTC's order of execution pending appeal. Yes, the COMELEC committed grave abuse of discretion. Grave abuse of discretion occurs when judgment is exercised in a capricious, whimsical, or arbitrary manner equivalent to lack of jurisdiction. The COMELEC may not interfere with a valid discretionary act of a trial court absent such abuse. The COMELEC erred in disregarding established jurisprudence recognizing shortness of term and public interest as valid grounds for execution pending appeal. Worse, it gave due course to a petition tainted with blatant forum shopping. Its actions constituted grave abuse of discretion warranting annulment. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.